2018 bar question. Orphaned when still an infant, Rocky lived under the care of his grandmother Rosario. Now 18, Rocky entered Rosario's bedroom who outside doing her daily marketing. He ransacked the bedroom and took Rosario's money and valuables amounting to 100,000 pesos. When Rosario came home, she found her room in disarray and her money and valuables gone. She confronted Rocky, who confessed to taking the money and valuables to pay off his debts. What crime, if any, did Rocky commit? 2.5%. Answer. Rocky committed the crime of theft by taking his grandmother's money and valuables. He committed theft under Article 308 of the RPC, which says, theft is committed by any person who, with intent to gain, but without violence against or intimidation of persons nor force upon things, shall take the personal property of another. Question letter B. Does he incur criminal and or civil liability? 2.5%. Answer. Rocky could incur civil liability only, not criminal liability, as Article 332 of RPC provides that no criminal but only civil liability shall result from the commission of the crime of theft, swindling or malicious mischief committed or caused mutually by the following persons. 1. Spouses, ascendants and descendants, or relatives by affinity in the same time. 2. The widowed spouse which respect to the property which belonged to the deceased spouse before the same time shall have passed into the possession of another, and 3. Brothers and sisters and brothers-in-laws and sisters-in-law, if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. 2017 bar question. What is now the age of doli incapax in the Philippines? 2%. Answer. With or without if the accused is 15 years of age or below. Minority is an exempting circumstance. Section 6 of RA number. Discernment. The accused of such age is exempt from criminal liability. Lack of discernment is conclusively presumed. Hence, the age of doli incapax in the Philippines is now 15 years of age or under. 2016 bar question. Charges d'affaires Volvic of Latvia suffers from a psychotic disorder after he was almost assassinated in his previous assignment. One day, while shopping in a mall, he saw a group of shoppers whom he thought were the assassins who were out to kill him. He asked for the gun of his escort and shot 10 people and wounded 5 others before he was subdued. Wounded persons required more than 30 days of medical treatment. What crime or crimes, if any, did he commit? Explain. Answer. Volvic committed 5 frustrated murders for the unwounded victims and frustrated murders for the wounded victims. Treachery is present since the sudden attack rendered the victims defenseless. The nature of the weapon used in attacking the victims and extent of the wounds today, the 5 victims showed intent to kill. His psychotic condition is not an exempting circumstance of insanity in the absence of showing that there is a complete deprivation of intelligence in accordance with the cognition test. However, he is immune from criminal prosecution, since the position of Volvic as charges d'affaires is diplomatic. He is vested with blanket diplomatic immunity from criminal suit. Minutier vs. Honorable CA, GR number 142396, February 11, 2003. 2014 bar question. Macho married Ganda, a transgender. Macho was not then aware that Ganda was a transgender. On their first night, after their marriage, Macho discovered that Ganda was a transgender. Macho confronted Ganda and a heated argument ensued. In the course of the heated argument, a fight took place wherein Ganda got hold of a knife to stab Macho. Macho ran away from the stabbing thrusts and got his gun, which he pointed at Ganda just to frighten and stop Ganda from continuing with the attack. Macho had no intention at all to kill Ganda. Unfamiliar with guns, Macho accidentally pulled the trigger and hit Ganda, that caused the latter's death. What was the crime committed? 4%. Answer. Considering that death resulted from Macho's accidentally pulling the trigger of his gun, and even if there be no intent to kill, the crime is still homicide. Here, intent to kill is conclusively presumed when the victim dies as a consequence. Alternative answer. Macho did not commit a crime. His act of pointing his gun at Ganda is a reasonable means to repel an unprovoked, unlawful aggression committed by the latter. Since his act of pointing the gun is lawful, the firing thereof, which hit Ganda causing her death, should be treated as accident, which is an exempting circumstance. In People v. Tianco, CA 63 OG 3610, the accused, who accidentally fired his gun while exercising his right of self-defense, was acquitted. His act of confronting Ganda about his real gender cannot be considered sufficient provocation on his part. 2010 bar question. Immediately after murdering Bob, Jake went to his mother to seek refuge. His mother told him to hide in the maid's quarters until she finds a better place for him to hide. After 2 days, Jake transferred to his aunt's house. A week later, Jake was apprehended by the police. Can Jake's mother and aunt be made criminally liable as accessories to the crime of murder? Explain. Answer. Obviously, Jake's mother was aware of her son's having committed a felony, such that her act of harboring and concealing him renders her liable as an accessory. But being an ascendant to Jake, she is exempt from criminal liability by express provision of Article 20 of the Revised Penal Code. On the other hand, the criminal liability of Jake's aunt depends on her knowledge of his commission of the felony. Her act of harboring and concealing Jake would render her criminally liable as accessory to the crime of murder. Otherwise, without knowledge of Jake's commission of the felony, she would not be liable. 2010 bar question. While his wife was on a 2-year scholarship abroad, Romeo was having an affair with his maid Dulcinea. Realizing that the affair was going nowhere, Dulcinea told Romeo that she was going back to the province to marry her childhood sweetheart. Clouded by anger and jealousy, Romeo strangled Dulcinea to death while she was sleeping in the maid's 45 quarters. The following day, Romeo was found catatonic inside the maid's quarters. He was brought to the National Center for Mental Health, where he was diagnosed to be mentally unstable. Charged with murder, Romeo pleaded insanity as a defense. Will Romeo's defense prosper? Explain. 2%. Answer. No, Romeo's defense of insanity will not prosper because even assuming that Romeo was insane when diagnosed after he committed the crime, insanity as a defense to the commission of crime must have existed and proven to be so existing at the precise moment when the crime was being committed. The fact of the case indicate that Romeo committed the crime with discernment. Question. What is the effect of the diagnosis of the NCMH on the case? 2%. Answer. The effect of the diagnosis made by NCMH is possibly a suspension of the proceedings against Romeo and his commitment to appropriate institution for treatment until he could already understand the proceedings. 2007 bar question. Mackie, a security guard, arrived home late one night after rendering overtime. He was shocked to see Joy, his wife, and Ken, his best friend, in the act of having sexual intercourse. Mackie pulled out his service gun and shot and killed Ken. The court found that Ken died under exceptional circumstances and exonerated Mackie of murder, but sentenced him to desterru, conformably with Article 247 of the Revised Penal Code. The court also ordered Mackie to pay indemnity to the heirs of the victim in the amount of 50,000 pesos. Did the court correctly order Mackie to pay indemnity, even though he was exonerated of murder? Explain your answer. 10%. Answer. No, the court did not act correctly in ordering the accused to indemnify the victim. Since the killing of Ken was committed under the exceptional circumstances in Article 247 of Revised Penal Code, it is the consensus that no crime was committed in the light of the pronouncement in People v. Kozaker 79 Phil. 672-1947, that banishment desterru is intended more for the protection of the offender rather than as a penalty. Since the civil liability under the Revised Penal Code is the consequence of criminal liability, there would be no legal basis for the award of indemnity when there is no criminal liability. Alternative answer. Yes, because the crime punishable by desterru was committed, which is death under exceptional circumstances, under Article 247 of the Revised Penal Code. 2000 bar question. While they were standing in line awaiting their vaccination at the school clinic, Pomping repeatedly pulled the ponytail of Katrina, his 11 years, 2 months and 13 days old classmate in grade 5 at the Sampaloc Elementary School. Irritated, Katrina turned around and swung at Pomping with a ball pen. The top of the ball pen hit the right eye of Pomping, which bled profusely. Realizing what she had caused, Katrina immediately helped Pomping. When investigated, she freely admitted to the school principal that she was responsible for the injury to Pomping's eye. After the incident, she executed a statement admitting her culpability. Due to the injury, Pomping lost his right eye. Is Katrina criminally liable? Why? 3%. Answer: no, Katrina is not criminally liable, although she is civilly liable. Being a minor less than 15 years old, although over 9 years of age, she is generally exempt from criminal liability. The exception is where the prosecution proved that the act was committed with discernment. The burden is upon the prosecution to prove that the accused acted with discernment. The presumption is that such minor acted without discernment, and this is strengthened by the fact that Katrina only reacted with a ballpen, which she must be using in class at the time, and only to stop Pomping's vexatious act of repeatedly pulling her ponytail. In other words, the injury was accidental. Please take note that under RA 9344, children below 15 years old do not incur criminal liability, but her parents or guardian shall be liable for civil indemnity. 9098 bar question. John, an 8-year-old boy, is fond watching the television program Zao Rangers. One evening while he was engrossed watching his favorite television show, Petra, a maid, changed the channel to enable her to watch Home Along the Rails. This enraged John, who got his father's revolver and, without warning, shot Petra at the back of her head, causing her instantaneous death. Is John criminally liable? 2%. Answer: no, John is not criminally liable for killing Petra because he is only 8 years old when he committed the killing. A minor below 9 years old is absolutely exempt from criminal liability, although not from civil liability. 9097 bar question. After killing the victim, the accused absconded. He succeeded in eluding the police until he surfaced and surrendered to the authorities about 2 years later. Charged with murder, he pleaded not guilty, but after the prosecution had presented 2 witnesses implicating him to the crime, he changed his plea to that of guilty. Should the mitigating circumstances of voluntary surrender and plea of guilty be considered in favor of the accused? Answer: voluntary surrender should be considered as a mitigating circumstance. After 2 years, the police were still unaware of the whereabouts of the accused, and the latter could have continued to elude arrest. Accordingly, the surrender of the accused should be considered mitigating because it was done spontaneously, indicative of the remorse or repentance on the part of said accused, and therefore, by his surrender, the accused saved the government expenses, efforts, and time. However, the plea of guilty can no longer be appreciated as a mitigating circumstance, because the prosecution had already started with the presentation of its evidence. Article 13, Paragraph 7 of Revised Penal Code. 9096 bar question. Hilario, upon seeing his son engaged in a scuffle with Renee, stabbed and killed the latter. After the stabbing, he brought his son home. The chief of police of the town, accompanied by several policemen, went to Hilario's house. Hilario, upon seeing the approaching policemen, came down from his house to meet them and voluntarily went with them to the police station to be investigated in connection with the killing. When eventually charged with and convicted of homicide, Hilario, on appeal, faulted the trial court for not appreciating in his favor the mitigating circumstance of voluntary surrender. Is he entitled to such a mitigating circumstance? Explain. Answer: yes, Hilario is entitled to the mitigating circumstance of voluntary surrender. The crux of the issue is whether the fact that Hilario went home after the incident, but came down and met the police officers and went with them, is considered voluntary surrender. The voluntariness of surrender is tested if the same is spontaneous, showing the intent of the accused to submit himself unconditionally to the authorities. This must be either a. because he acknowledges his guilt, or b. because he wishes to save them the trouble and expenses necessarily incurred in his search and capture. Reyes Commentaries, p. 303. Thus, the act of the accused in hiding after commission of the crime, but voluntarily went with the policeman who had gone to his hiding place to investigate, was held to be mitigating circumstance. People v. Darrett, cited in Reyes Commentaries, p. 299. 9095 bar question. Victor, Ricky, Rod and Ronnie went to the store of Mang Pandoy. Victor and Ricky entered the store while Rod and Ronnie posted themselves at the door. After ordering beer, Ricky complained that he was shortchanged, although Mang Pandoy vehemently denied it. Suddenly Ricky whipped out a knife. He announced, "Hold up, Ito," and stabbed Mang Pandoy to death. Rod boxed the store's salesgirl Lucy to prevent her from helping Mang Pandoy. When Lucy ran out of the store to seek help from people next door, she was chased by Ronnie. As soon as Ricky had stabbed Mang Pandoy, Victor scooped up the money from the cash box. Then Victor and Ricky dashed to the street and shouted, "Tomekbo na kayo." Rod was 14 and Ronnie was 17. The money and other articles looted from the store of Mang Pandoy were later found in the house of Victor and Ricky. Discuss fully the criminal liability of Victor, Ricky, Rod and Ronnie. Answer. All are liable for the special complex crime of robbery with homicide. The acts of Ricky in stabbing Mang Pandoy to death, of Rod in boxing the salesgirl to prevent her from helping Mang Pandoy, of Ronnie in chasing the salesgirl to prevent her in seeking help, of Victor in scooping up money from the cash box, and of Ricky and Victor in dashing to the street and announcing the escape, are all indicative of conspiracy. The rule is settled that, when homicide takes place as a consequence or on the occasion of a robbery, all those who took part in the robbery are guilty as principals of the crime of robbery with homicide, unless the accused tried to prevent the killing. People v. Bilo, 224 scra 218. Further, the aggravating circumstance of craft could be assessed against the accused for pretending to be customers of Mang Pandoy. Although Rod is only 14 years old, his act of boxing Lucy to prevent her from helping Mang Pandoy is a clear sign of discernment, thus he cannot invoke exemption from criminal liability under Article 12, Paragraph 3 of RPC. Rod and Ronnie are, however, entitled to 2 and 1 degrees lower, respectively, from the penalty of the principal under Article 68 of RPC. Note, under RA 9344, Rod will not incur criminal liability because he was only 14 when the crime was committed. As for Ronnie, who was 17 then, he shall be liable because the facts show that he acted with discernment. 9091 bar question. A raped X in the process. X resisted and slapped A. Angered, A grabbed a stone and hit X. She was dying when A consummated the sexual attack. A psychiatrist from the National Center for Mental Health testified that he conducted physical, mental and psychological examinations on A and found him to be suffering from a mental disorder classified under organic mental disorder with psychosis. A's father testified that A was playful, but cruel to his brothers and sisters, stole his mother's jewelry, which he sold for low sums, wandered naked sometimes, and oftentimes did not come home for extended periods of time. The prosecution, on the other hand, presented an array of witnesses to prove that was lucid before and after the crime was committed and that he acted with discernment. After trial, the court convicted the accused and sentenced him to life imprisonment, considering that under the Constitution death penalty could no longer be imposed. Given the conflicting testimonies as to sanity of the accused, was the trial court correct in ruling out insanity as an exempting circumstance in this case? Is the sentence of life imprisonment a correct imposition of penalty? Answer. Yes, the court is correct in ruling out insanity as an exempting circumstance. While there was testimony that A was suffering from a mental disorder, the testimony of A's father disclosed that A had lucid interval. Because what is presumed is sanity, not insanity, it is to be presumed that A was sane when he committed the crime. Consequently, evidence being wanting that A is completely deprived of reason at the moment of committing the crime, he should be liable. Besides, the crime committed and the acts done by the accused in the commission of the crime hardly reconciles with insanity of the offender, as rape presupposes evident premeditation. 1989 bar question. Nicandro borrowed Valeriano's gun, a high-powered M16 rifle, to hunt wild pigs. Nicandro was accompanied by his friend, Felix. On their way to the hunting ground, Nicandro and Felix met Pedro near a hut. Pedro told them where to hunt. Later, Nicandro saw a pig and then shot and killed it. The same bullet, however, that killed the pig struck a stone and ricocheted, hitting Pedro on his breast. Pedro later died. May Nicandro be held liable for the death of Pedro? Explain. Answer. Nicandro may be held liable for the death of Pedro. While Pedro's death would seem to be accidental, the requisites of exempting circumstance of accident are not all present. Said requisites are: 1. A person is performing a lawful act. 2. With due care. 3. He causes an injury to another by mere accident. 4. Without fault or intention of causing it. Article 12, paragraph 4 of RPC. When Nicandro borrowed Valeriano's high-powered M16 rifle and used it for hunting wild pigs, he committed the crime of illegal possession of firearms, as he does not appear to have either a license to possess a high-powered gun or to carry the same outside of his residence. At the time he shot at the wild pig, therefore, Nicandro was not performing a lawful act. Furthermore, considering that the M16 is a high-powered gun, Nicandro was negligent in not foreseeing that bullets fired from said gun may ricochet. 1979 bar question. X, engaged in illegal gambling, was accused of bribing Y, a policeman. X's defense was fear of reprisal from the police in case of non-payment of bribe money. He testified that when he attempted to stop giving bribe money to Y, the police raided his establishment without warrant for half a dozen times. Y also threatened to plant incriminating evidence on him. X was also manhandled by Y on the pretext of resisting arrest. X would park his police jeep in front of his house, obviously 48, to drive away his regular customers. X's defense is that he bribes Y under the impulse of an uncontrollable fear of an equal or greater injury. Please decide. Answer. X's defense that he bribed Y, a policeman, under the impulse of an uncontrollable fear of an equal or greater injury, is untenable. This exempting circumstance can be appreciated if a person is compelled to commit a crime by another through intimidation. It is also essential that the person intimidated must not have any opportunity for escape or to avoid the threat. The facts of the problem show that X could have easily reported to the authorities the alleged acts of harassment committed by the policeman. Lastly, the fear must not be speculative or fanciful, but must be actual or real. All the acts testified to by X do not show any actual or direct intimidation on the part of Y in case of non-payment of the bribe.